Hi everyone, welcome from Law with Dunk, the Law Guy, and today I'll be the Dunkerine, as cringeworthy as it sounds. I cringe myself, so I don't know what you guys are thinking, but I won't be doing it with the mask because it's a child's mask. It just makes my face look fat, even because I've got a fat face. But as you can see, I will be wearing the claws. They're just really inconvenient. It's so difficult picking things up off the ground, with these. Anyway, so we're going to do day 53 of the Case a Day series journey, covering cases across criminal law, tort law, contract law, and the English legal system. I'm just getting comfy. Right, okay. If you ever have a case you want me to cover, pop it in the comments section and I'll get round to it. Today I'd like to cover R.V. Nelson 2013. I haven't included this case in my class handouts for when I teach, and so I consider it a low priority case, if that. However, it is briefly mentioned in the latest AQA textbook, and so I've decided to provide a recording on it just in case it's of any use to anyone. In terms of this case's relevance to the criminal offence of assault, I suppose it helps us understand the definition of assault a little more, specifically the actus reus of an assault. We know that an assault is defined as an act, requirement 1 of the actus reus, that causes the victim to apprehend, requirement 2, immediate, requirement 3, unlawful, requirement 4, violence. So I'll just go through that. We know that an assault is defined as an act that causes the victim to apprehend, immediate, unlawful violence. Again, that's just the actus reus of an assault there. And the mens rea of an assault is either intention, I always stress direct intent as of R.V. Mohan, or recklessness, which is subjective recklessness as of R.V. Cunningham, to cause the victim to apprehend immediate unlawful violence. And the Court of Appeal stressed in R.V. Nelson 2013 that for an assault to occur, the defendant must have done something of a physical kind which causes someone else to apprehend that he or she is about to be struck. That's a direct quote from the Court of Appeal case in R.V. Nelson. So anyway, touching upon the case facts to help us understand this case. In this case, at trial, the defendant was charged with 2 offences in the Crown Court. One offence being that of an assault by beating, which I've never heard of before, so I assume this is similar to a battery maybe. Correct me if I'm wrong, please do. And the other offence being that of an assault occasioning actual bodily harm under Section 47 of the Offences Against the Person Act 1861. The prosecution at trial argued that the defendant, who was a prisoner serving life imprisonment, punched a prison officer who had attempted to search the defendant with an electronic metal detector. This would be where the first charged offence comes into play. The prosecution further argued that in attempting to restrain the defendant, another prison officer suffered an eye injury, which is where the second charged offence is relevant. At trial, the judge directed the jury to acquit the defendant on the second offence the defendant was charged with, i.e. the Section 47 offence, but to proceed to consider whether the defendant could be guilty of the first offence the defendant was charged with, i.e. the assault by beating. The defendant argued that whilst the defendant acknowledged he had thrown a punch at the first prison officer due to the officer apparently moving the metal detector in a threatening manner, he actually went on to miss the first prison officer. As a result of this admission, the trial judge allowed the charge of assault by beating, which I've again never heard of before, to be substituted instead for an alternative charge, i.e. that of the common law offence of assault, which ultimately led to the jury finding the defendant guilty of this offence. The conviction of assault here was upheld on appeal by the Court of Appeal, which led to this appellate court confirming that an assault requires the defendant to have done something of a physical kind which causes someone else to apprehend that he or she is about to be struck, thus providing some guidance as to when the actus reus of an assault takes place. Again, I think there are much more important cases to consider, but if you wish to learn about this case, I hope this recording has helped and this ridiculous costume hasn't stopped you. Anyway, and that's it for today. Thank you from Law with Dunk, the Law Guy, and hopefully I'll see you tomorrow.